Hello and welcome to this program titled An Overview of Personal Guarantees. This program is another in the 10-Minute Tips program series for credit and collection professionals. My name is Michael Dennis. I'll be the presenter today. Let's begin. Introduction. A guarantor accepts responsibility for paying a debt if a company or person for whom the guarantee is being offered fails to do so. In business-to-business debt collections, one of the most common guarantees that is sought by the creditor company is a personal guarantee. Often what happens is that the credit grantor will ask the business owner to guarantee the debts that have been incurred by the company. And that may sound counterintuitive, but the point is that we're trying to get the business owner to become personally liable for the debts of the company. So by signing a personal guarantee, the guarantor becomes personally liable for the debt. You should be aware that normally a personal guarantee that's being signed by an individual in support of open account terms being offered to one of your customers is in fact an unsecured personal guarantee. What that means is that the guarantee is not tied to any specific asset that's being offered to you as collateral. Reasons creditor companies request personal guarantees. We want a personal guarantee fundamentally because having it increases the chances of getting paid if in fact we agree to offer a customer open account terms. And why it increases the chances of getting paid is this: because by having a guarantee from an individual, what it means is that there are additional assets that are available to your company as the creditor company if the debtor company fails. Specifically, the additional assets that are available to you, the creditor company, if the debtor company fails, are the personal assets of the guarantor. Like what? Like their home, like their bank account, like their car, like things they own individually. A reason that we request personal guarantees is that if a customer defaults, we, the creditor company, can pursue payment immediately from the guarantor. By the way, this is true if a company defaults in the form of a bankruptcy. We can still pursue the individual guarantor in that scenario. In addition, a personal guarantee can be useful if an applicant company doesn't qualify for any open account credit limit or doesn't qualify for the credit limit that they have requested from us. What happens in effect is this: the creditor company bases the credit limit on both the creditworthiness of the company as well as the creditworthiness of the guarantor. As a result, there are times when you get a personal guarantee that you can in fact approve the credit limit requested rather than a lower credit limit or no credit limit, which is sometimes the case when there is no additional support for open account terms, and we're referring to additional support in this context as being a signed personal guarantee. How personal guarantees are used. So creditor companies often request guarantees as an additional assurance of payment at the time the application is received. What I mean by this is that some companies include along with their credit application a personal guarantee form. In other cases, what will happen is the creditor will receive and review the completed credit application from the applicant company, and based on that review, they will make a decision that the best way, or perhaps the only way, that they can offer open account terms to the applicant company is if in support of that credit limit and those open account terms, one or more guarantors are willing to sign a personal guarantee. The purpose of a personal guarantee is to mitigate your credit risk. Your credit risk relates to the risk of payment default, and it also relates to the risk of payment delays or serious payment delinquency. From your perspective, it's important to know that the use of personal guarantees has become fairly commonplace. Tight credit conditions may necessitate a more conservative credit granting approach. In other words, tight credit conditions may necessitate that you look to personal guarantees more often as an additional assurance that your company is going to get paid or is more likely to get paid, even if the debtor company defaults on payment. By the way, if one of the applicant companies you're looking at or a company you're doing business with has multiple owners, your company as the creditor may want each of the owners to sign a personal guarantee. And it's important to understand that there's no limit to the number of personal guarantees that you can have on file in support of any specific customer's credit limit or credit limit request. So, for example, you might be doing business with, let's just say, a partnership. And let's, for convenience, assume there are 5 partners in this partnership. You could, in theory, request personal guarantees from all of those 5 partners. Or you could request personal guarantees from 5 unrelated parties if those unrelated parties are, in fact, willing to sign a personal guarantee in support of your decision to extend open account terms to that partnership. Limits on guarantees. From time to time, when you are in discussions with a potential guarantor in connection with a personal guarantee, what will happen is you will at some point present them with your standard personal guarantee form for them to sign. Please be aware that a personal guarantee is a contract, and these contracts normally are reviewed and approved by your attorney. That contract is likely to include a clause that addresses the idea that the guarantor has an uncapped and unlimited personal liability for the debts of the company that the individual is guaranteeing. However, in these discussions, from time to time, a guarantor may want a dollar cap, a dollar maximum limit on their liability for the debts incurred by the debtor company that they're guaranteeing. So we want unlimited personal liability. They may create a cap of $10,000, $50,000, $100,000. These are just examples. And that is potentially problematic for the creditor company. In addition, guarantors often want to insert an expiration date in their personal guarantee. They may want, as an example, to indicate that their personal guarantee expires in 6 months, or in 1 year, or in 3 months. And not surprisingly, credit grantors prefer not to accept any time limitation on the duration of the personal guarantee form. In addition, from time to time, you may see that a guarantor wants to exclude certain of their assets from the guarantee. For example, the guarantor may say, I'm willing to pledge my personal assets, but I will not pledge any real property, any my home or any other property that I own as part of this personal guarantee of the debts of that company. And not surprisingly, you as a creditor prefer not to permit the guarantor to exclude any of the guarantor's assets from the pool of assets that would be available to you if you had to sue the guarantor for payment under the personal guarantee. The basic advice is fairly straightforward. When you have a personal guarantee, you have a document, you have a contract that has been reviewed and has been signed off by your attorney. When or if a customer wants to amend that contract, that would necessitate a discussion at a minimum with your attorney, and likely with your attorney and your senior management, about whether or not you're willing to accept the modifications that are being proposed to your contract by the person to whom you've sent the contract for signature. By the way, if you're interested in hearing the entire 1-hour presentation on this topic, please contact the Sponsoring Credit Association for more information, and thank you very much for your time.